for the primary purpose of representing the legislative and oversight priorities of Native Americans. The committee is the first stop in the Senate towards achieving these priorities and broadly fulfilling the United States' trust and treaty obligations. But Congress is capable of forgetting these obligations. Our trust and treaty obligations are not just abstract promises, they are enshrined in the United States Constitution, a constitutional mandate that committee members carry with them as they go about their work in the Senate. And when it comes to the Violence Against Women Act, Congress does not have the luxury of forgetting this mandate. That's because every member of this committee knows that public safety in Native communities is a problem. We've heard from tribal leaders, we've heard from law enforcement, and we've heard from the families of Native victims. Their message is consistent. Doing nothing is not an option. We've heard that message loud and clear in 2013 with the last VAWA reauthorization. Almost a decade ago, this committee came together on a bipartisan basis and voted to restore tribal criminal jurisdiction over non-Indians who commit domestic violence in Indian country. That vote, one of the first that I took as a new member of the Senate and of this committee, was Congress's first real step towards restoring justice for Native communities. Because before VAWA in 2013, when tribal law enforcement was called to the scene of a crime in Indian country, the officer had to figure out the nature of the crime, the status of the land where the crime occurred, whether the victim was an Indian, and whether the offender was an Indian. That meant tribal law enforcement officers, often the first responders on a crime scene, had to complete a complicated mental checklist before deciding whether to arrest or detain a suspect. It's no wonder tribes had their hands tied when it came to maintaining public safety on their own lands. And the criminals exploited this jurisdictional maze, preying on Native women and children and putting tribal communities in harm's way. But under VAWA 2013, tribes that opt to exercise special domestic violence criminal jurisdiction can cut through the legal red tape to enforce protection orders, and prosecute domestic violence crimes, all while safeguarding defendants' due process and constitutional rights. For nearly a decade, tribes have made at least 396 arrests for VAWA-related crimes and at least 133 subsequent convictions using special tribal jurisdiction. And despite the concerns of some, prior to the law passing, there have been 0 valid habeas corpus petitions filed and zero claims of due process violation. So what we will hear today is a story of success. Each of our witnesses will underscore the importance of special jurisdiction for Indian country. They will also lay out ways that Congress can help tribes and Native communities build on this success in the next VAWA reauthorization, closing jurisdictional gaps, creating parity, providing resources, and making sure that Native Americans are not invisible in public safety data. These are just a few of the common sense bipartisan solutions that our committee can and should work to advance. That's one of the many reasons I'm thankful for my partnership with Vice Chair Murkowski. She has been an extraordinary leader for Native people across the country, in Indian country, of course in Alaska, on behalf of Native Hawaiians, and especially in this case, on behalf of people who are victims of domestic violence. And we will continue to work together to make sure Indian country priorities are included in the Senate's coming Violence Against Women Act reauthorization. Finally, before I turn to Vice Chair Murkowski, I'd like to extend a special welcome and thanks to our witnesses for joining us today, and I look forward to your testimony and our discussion. Vice Chair Murkowski.
Thank you, Mr. Chairman, and indeed it is a genuine thank you. I want to thank you and your team for the very cooperative work that has gone into not only where we are in holding this very, very important hearing today, but in the work that we have done in preparing this draft legislation that has been publicly now released. It's been a little bit of a long process. I think we would all like to move more quickly, but I think we also want to do good work, and that's what this committee is committed to doing. So the focus today on what more we can be doing to ensure levels of protection for those who are subjected to violence in our Native communities, what more we can be doing for Native women around the country. This is a key priority for us, but how we knit this into the broader VAWA picture proposal is also very important. I think you've outlined, Mr. Chairman, that sometimes these issues of tribal jurisdiction are confusing, they're esoteric, but I want to emphasize that the impacts on the ground in Native communities, particularly in places like very rural Alaska, they are very real, they are very tragic. In 2019, we had the Attorney General come out to a small Native village. He looked around, he talked to the people, he left, and he declared a law enforcement emergency. It was based on the fact that Alaska has the highest per capita crime rate in the country. We face a unique jurisdictional landscape, but jurisdictional complexity should not deny safety or justice, and that's what we've seen happening. In 2013, Congress passed the Violence Against Women Act. In Title IX of VAWA 2013, as it's commonly called, Congress enacted what's been described as a partial elephant fix by recognizing the inherent authority of tribes to prosecute and punish certain domestic violence crimes committed by non-Indians against Indian women. At that time, this act was described as unprecedented. Some members of Congress and the news media pushed a narrative that tribal governments somehow would not be fair, they wouldn't safeguard the rights of non-Indian defendants, something that we all knew was far from the truth. And Mr. Chairman, as you have pointed out, 8 years later, the parade of horrible that so many had predicted did not happen. I'm proud to report, as you have, that, and we're going to hear from our witnesses, despite all the horror stories, non-Indian defendants experience a tribal justice system that treats them fairly and perhaps in some ways with more attention than the state or the federal system. And that's why I believe we have a moral imperative here in Congress that we take action to further restore and improve the implementation of this special tribal criminal law jurisdiction over non-Indians who commit violent crimes in our Native communities. I firmly believe that by empowering tribal courts in this way, we can help combat this major public safety issue that affects Native people and Native children. We know the statistics on this committee, we say them a lot, but they bear repeating. American Indians and Alaska Natives are the victims of rape, sexual assault, and domestic violence in numbers far out of proportion to the level that these crimes are committed outside of Native communities. And most often, these crimes are committed by non-Indian men. In Alaska, the rates of violence experienced by Alaska Natives are horrific. There's no other word than horrific. According to a report prepared by the Indian Law and Order Commission, Alaska Native women are overrepresented by nearly 250% among women domestic violence victims in our country. Most Native communities in rural Alaska have no local law enforcement physically present. 1 out of 3 Native communities, 1 out of 3, has no local law enforcement that is physically there. So think about what that means if you are a victim of violence in your home, if your children have been targeted and there is no presence for law enforcement. And currently, Alaska tribes, many of the tribes don't have the tools that they need to address this violence in our tribal communities. Only 1 Alaska tribe could potentially implement the special jurisdiction. This is wrong, and we have recognized that, and we have to make it right. And we need to do it in a way that recognizes the unique jurisdictional situation that we have in Alaska. We're a PL 280 state, Alaska is. The Alaska Native Claims Settlement Act, ANCSA, is going to be celebrating its 50th anniversary just this next week. But it created a new and different approach to tribal land tenure from the lower 48 reservation system. I know it still comes as a surprise to some, but we've got half the tribes in the entire country, but we only have 1 Indian reservation in our state. After the U.S. Supreme Court decision in the Venati case, in which the court held that ANCSA lands are not Indian country, it became the state's duty, largely alone, to provide for public safety and justice for Alaska Natives. So we're in a situation that just isn't tenable right now. But I'm happy to report that we have an Alaska solution to this complex jurisdictional situation in our state, and we're calling it the Alaska Public Safety Empowerment Pilot Project. We're rolling it out as a part of the discussion draft text title for folks to see, give us your feedback on it. It builds on previous legislation that you've seen from me. It's the product of years of work with tribal advocates and smart lawyers. We're going to be able to hear from Michelle Demert as part of this panel. She has been a great help. But this pilot project will empower a limited number of Alaska tribes to exercise special criminal jurisdiction over certain crimes that occur in villages in Alaska. These tribes will have to meet certain criteria, including having a tribal justice system that can adequately safeguard the rights of defendants. But I am absolutely confident that Alaska tribes are up to this task. Overall, I think we've got a unique opportunity here, working in a cooperative and a bipartisan way to make a positive difference in the safety of our Native communities for Native women and children across our country. And I hope, Mr. Chairman, that we seize it. So again, I want to thank the witnesses for participating today, especially Michelle Demert of the Alaska Native Women's Resource Center. Mr. Chairman, thank you for helping in such a strong and constructive way to get us here today. Thank you.
Thank you, Vice Chair Murkowski. Senator Tester would like to introduce one of the witnesses for us.
Yeah, I got a real brief opening statement, but first of all, I want to thank you, Mr. Chairman, and Ranking Member Murkowski, for all the good work that you've done in this committee, and particularly on this issue. There's 7 people on the witness list today, 2 of them in person, and welcome, and 5 of them virtually, so there's a wealth of information we can get. And I would also like to welcome the Montanans we have in the House today. Appreciate you folks being here. Look, it is very important to have this hearing. The Violence Against Women Act saves lives, plain and simple. Reauthorization of VAWA is long overdue, and without reauthorization, the life-saving resources that it offers are put to risk. Tribal sovereignty needs to be in the forefront of these discussions around VAWA reauthorization, and rightfully so, because when it comes to making decisions about Indian country, tribes need to be the ones driving the bus. This being said, it is my pleasure to introduce Chief Judge Stacey Forstar today, someone who knows about what it takes to make these critical decisions. She is a member of the Fort Beck, Assiniboine, and Sioux tribes who specialize in Indian law. While working in her home community, she has served as prosecutor, as an associate judge, and now holds the office of Chief Judge at Fort Beck Tribes. She has been a key player in implementing VAWA for the tribe since it was accepted into a pilot program back in 2015. All is which to say, she knows what she's talking about, and I look forward to hearing from Chief Forstar and the other 6 witnesses here today. Thank you, Mr. Chairman.
Thank you, Senator Tester. Senator Lujan for an opening statement.
Thank you, Chair Schatz and Vice Chair Murkowski for holding this hearing to examine the tribal title of the Violence Against Women Act reauthorization. And thank you for our witnesses for joining us today. I would like to welcome Elizabeth Reese-Yampovi of Nambe Pueblo, and also introduce Governor Michael Chavarria of Santa Clara Pueblo. Santa Clara Pueblo is the first and only pueblo or tribe in New Mexico to exercise special domestic violence criminal jurisdiction under the Violence Against Women Act. As governor from 2006 to 2008 and 14 to 2021, Governor Chavarria oversaw the implementation of the criminal jurisdiction, creating a new tribal code in 2020 to meet federal standards under VAWA, directing federal grant funding to train judges and defense counsel and law enforcement personnel for this purpose. It's my pleasure and honor to have you here today, Governor, and I look forward to highlighting the Pueblo's leadership in exercising this jurisdiction and how the Native Youth and Tribal Officer Protection Act I introduced today will fill in many of the gaps left in place by the 2013 VAWA. Thank you, Chair, and I yield back.
Thank you, Senator Lujan. I'll now turn to our witnesses. We have 7. Allison Randall, Principal Deputy Director, Office of Violence Against Women in the U.S. Department of Justice. Wizipan Little Elk Garriott, Principal Deputy Assistant Secretary, Indian Affairs at the U.S. Department of Interior. J. Michael Chavarria, Governor, Santa Clara Pueblo, Española, New Mexico. Fawn Sharp, President, the National Congress of American Indians. Stacy Forstar, Chief Judge, Fort Peck, Assiniboine, and Sioux Tribes, Poplar, Montana. Elizabeth Reese, Assistant Professor of Law at Stanford University. Michelle Demerit, Director, Law and Policy Center, Alaska Native Women's Resource Center in Fairbanks, Alaska. I want to remind our witnesses that your full written testimony will be made part of the official hearing record. Please confine your remarks to 5 minutes exactly or less if you can. And Principal Deputy Director Randall, the committee's rules, specifically Rule 4B, requires that if a federal witness misses the committee's 48-hour deadline for submission of testimony, the witness must state on the record why the testimony was late. Please be prepared to start your testimony with an explanation on why you were unable to comply with the committee's rule. And now we will recognize the witnesses, starting with Principal Deputy Director Randall.
Thank you so much, Chairman Schatz, Vice Chairman Murkowski, and esteemed members of the committee. My apologies, and please excuse the delayed submission of testimony due to the lengthy interagency clearance process and the department's comprehensive review. I'm honored to be here to discuss implementation of special domestic violence criminal jurisdiction, how it has made a real difference in addressing violence against Native women, and how, working together, we can continue to make progress in addressing these devastating crimes. Prior to the Violence Against Women Act Reauthorization of 2013, or VAWA 2013, even violent crimes committed by a non-Indian husband against his Indian wife in the presence of their Indian children in their home on the Indian reservation could not be prosecuted by the tribe. This lack of jurisdiction left many severe acts of domestic and dating violence unprosecuted and unpunished. At the same time, Native American women continued to suffer unacceptably high rates of violence. More than half of American Indian and Alaska Native women have experienced physical violence by an intimate partner in their lifetimes. Congress acted to bridge this critical enforcement gap when VAWA was reauthorized in 2013 by recognizing tribes' inherent power to exercise special domestic violence criminal jurisdiction, or SDVCJ, over certain defendants, regardless of their Indian or non-Indian status, who commit acts of domestic violence, dating violence, or who violate certain protection orders in Indian country. Congress also required that participating tribes provide protections for defendants' rights and civil liberties. In the years since VAWA 2013 has passed, 28 tribes have reported that they have implemented SDVCJ. VAWA 2013 has empowered these tribes to hold accountable long-time abusers who previously had evaded justice. And the experience of the implementing tribes has demonstrated that tribal authorities can and do protect the rights of non-Indian defendants. 7 years' experience has also shown that there are gaps in SDVCJ that undermine tribal efforts to protect victims and hold offenders accountable. The National Congress of American Indians 2018 report on SDVCJ documents cases that could not be brought and charges that could not be filed due to these gaps. Department of Justice officials have heard from tribal leaders year after year at our annual Violence Against Indian Women consultation that tribes cannot prosecute co-occurring crimes such as child abuse, assaults on tribal officials, as well as sexual assault committed by non-natives. The stories are heartbreaking. That's why the Department of Justice urges Congress to recognize tribal jurisdiction that will allow tribes to hold accountable non-Indian perpetrators of the crimes of sexual violence, sex trafficking, domestic violence against child victims, stalking, elder abuse, and assault against law enforcement officers when offenders commit such crimes on tribal territory. I would also like to address the fact that tribes in Alaska face additional challenges in protecting victims and responding to offenders. The vast distances, remote locations, and an inability to exercise SDVCJ under the current legal framework. Given the high rates of violence experienced by Native women in Alaska, we are committed to working with the tribes and Congress to address these challenges and empower tribes in Alaska to confront the violence in their communities. The department continues to listen to tribes and support their exercise of SDVCJ. We've heard from tribal leaders that they need access to funds to support the day-to-day costs of SDVCJ. So today I am pleased to announce OVW is issuing 11 awards to implementing tribes to defray these costs. And to further our commitment to finding solutions that work for Alaska Native tribes, I'm also pleased to announce today that the department's annual consultation will be held in Alaska next year. In closing, SDVCJ has been a success, but many survivors have been left behind and perpetrators not held fully accountable because of its limitations. Congress must act. I appreciate the time and attention of this committee and look forward to answering your questions and working with you on this crucial issue.
Thank you very much. Principal Deputy Assistant Secretary Garriott, please proceed.
Hello, good afternoon, Chairman Schatz, Vice Chairman Murkowski. In my language, I say, Chante washte nape chuzapalo. I greet you with a good heart. My name is Wiziprank Lilaut Garriott. I serve as the Principal Deputy Assistant Secretary for Indian Affairs at the U.S. Department of the Interior. Thank you for the opportunity to present the department's testimony supporting increased efforts to address violence in Indian country through implementation of the Tribal Special Domestic Violence Criminal Jurisdiction provisions in the Violence Against Women Act. This is an issue that is close to my heart. Many of my relatives have experienced hurt and trauma, including abuse as a child, domestic abuse, and even human trafficking at the hands of both Indian and non-Indian perpetrators. Sadly, living in fear is all too often the reality for many in Indian country. As members of this committee are aware, American Indians and Alaska Natives are more than 2 times as likely to experience violent crimes and at least 2 times more likely to experience rape or sexual assault and crimes than all of the other ethnicities. Violence does not happen in a vacuum, and this is why the Biden-Harris administration and the department support the expansion of tribal criminal jurisdiction beyond crimes of domestic violence as provided for in H.R. 1620, the Violence Against Native Women Act reauthorization. In line with this commitment, the department is working to reduce rates of domestic violence and violence against American Indian and Alaska Native people, collaborate with tribes and law enforcement agencies to equip tribes with the resources to respond to violence at the community level, implement models of tribal restorative justice, provide violence prevention services to diminish cycles of violence, and directly assist tribes with solving active and unsolved missing persons and homicide cases. And also working through the Bureau of Indian Affairs Office of Justice Services to implement the Missing and Murdered Indigenous Peoples Unit and to fulfill the requirements of the Savannah's Act, the Not Invisible Act, and the President's executive order on addressing the missing and murdered Indigenous peoples crisis. Assisting tribes with implementation of VAWA 2013 is another critical part of the department's commitment to addressing this epidemic. To date, 28 tribal governments maintain domestic violence jurisdiction over non-Indians, and many more tribal governments are in varying stages of planning and implementation. BIA-OJS provides support to those tribes currently implementing VAWA, as well as those with prospects for implementation. Despite the successes of VAWA 2013, jurisdictional gaps persist across Indian country. Many domestic violence cases involve children who were present in the home during alleged incidents. According to the Pasquayaqui tribe, from 2014 to 2017, 32 children, all under the age of 11, were exposed to violence, were victims, or reported the crime while it was in progress. Pasquayaquis numbers are not unique, and they demonstrate the need for tribal criminal jurisdiction to be expanded to include crimes against children. The time has come to honor tribal sovereignty and expand tribal criminal jurisdiction. H.R. 1620 provides for the expansion of tribal criminal jurisdiction beyond crimes of domestic violence to include crimes of dating violence, obstruction of justice, sexual violence, sex trafficking, stalking, and assault of law enforcement and correctional officers. Importantly, this legislation expands tribal criminal jurisdiction to crimes against children. Since time immemorial, Native nations have maintained effective justice systems. Today, tribal governments and courts continue to prove they are best suited. And this is why the department is pleased to support expansion of criminal jurisdiction to tribes in Maine and in Alaska. Due to remote nature and limited resources, many Alaska Native villages providing for public safety and law enforcement services remains a big challenge. Many villages lack many villages lack enforcement and in many cases must wait days for law enforcement response to an incident. The department understands and appreciates the unique jurisdictional and resource challenges faced by Alaska Native tribes. The administration and the department are firmly committed to working with tribal governments and this committee to meaningfully improve public safety and justice for all tribes. Thank you for the opportunity to testify today, and we'd be happy to answer any questions the committee may have.
Thank you very much, Mr. Garriott. Next, we have Governor Chavarria from the Santa Clara Pueblo.
Well, we are going to never how he answered ma in Marabahit, Aki, doing PAK, we are doing how we are going to call it, no, sort of power man. Good afternoon. In out of respect, Chairman. In my table language, I'm asking permission to speak, sir.
You have our permission. We are honored to
Thank you.
grant it.
Yes, thank you, Chairman. Well, thank you, Chairman. Ranking Member Murkowski and members of the committee for inviting me to testify on addressing violence in Native American communities. My name is Michael Chavarria. I serve as the governor for Santa Clara Pueblo. I testify today on behalf of the Pueblo Santa Clara to share our experience in the hope that it will assist you and your staff in broadening the current protections provided in VAWA Title IX Special Jurisdiction. The current protections go far, however, they do not go far enough. Specifically, law enforcement officers need to be protected when they respond to domestic violence calls. Currently, law enforcement officers are not included in VAWA Title IX Special Jurisdiction. However, law enforcement is called into extremely dangerous domestic violence situations. The Pueblo cannot protect our own officers when that perpetrator is a non-native. Specifically, children need to be protected as well from domestic violence. Currently, the protections of VAWA Title IX Special Jurisdiction only apply to past or present intimate partner relationship. However, children are commonly victims of domestic violence. So here's a real-world example of the need for protections for law enforcement. On February 11, 2013, a Santa Clara tribal police officer responded to a domestic violence disturbance. A tribal member and a non-native were living together in an intimate partner relationship within the Pueblo. Notified that their tribal member may be in danger, the tribal police went to the residence. While checking on the welfare of that tribal member, a drunken non-native individual assaulted the officer. The non-native perpetrator was not prosecuted by the state or the federal government. The Pueblo did its best to avoid the problem from happening again. The non-native was excluded from entering the Pueblo. However, the Pueblo looked for better solutions. So in March of 2013, VAWA Title IX Special Jurisdiction was signed into law. Santa Clara Pueblo immediately saw VAWA as an opportunity to protect our community, our people. We signed up to exercise special domestic violence criminal jurisdiction over non-native domestic violence perpetrators. With federal funding, we began to meet the federal standard to exercise this jurisdiction. So in the summer of 2020, we were finally approved by both the Department of Interior and the Department of Justice to exercise that jurisdiction. Currently, we are the only tribe in New Mexico exercising this special jurisdiction. So it is critical the definition of domestic violence victims in VAWA Title IX Special Jurisdiction should be expanded to include law enforcement officers and children. Today in the real world, our police officers are still not sufficiently protected when they respond to these potentially dangerous domestic violence calls. Our children are not protected either. And so special jurisdiction definitions requiring intimate relationships. So if that provision of VAWA are brought in to protect law enforcement and their children, we can then provide justice to our entire community. So broadening the definitions will protect real people. I thank you, Chairman, for VAWA. and for continuing the federal funding, which is very critical. I also submit my written testimony for the record and now stand for questions. Thank you, Chairman, members of the committee.
Thank you, Governor. Next, we have Fawn Sharp, President of the National Congress of American Indians.
Chairman Schatz, Vice Chairman Murkowski, and members of the Senate Committee on Indian Affairs. On behalf of the National Congress of American Indians, I'd like to thank you for holding this hearing on the success of the 2013 Violence Against Women Act and the critical need to reauthorize VAWA with strong tribal provisions. My name is Fawn Sharp, Vice President of the Quinault Indian Nation and President of NCAI. We welcome the opportunity to work with the committee to pass bipartisan legislation that continues to build on VAWA's success and includes 4 priorities for VAWA reauthorization. Number 1, amend 25 USC Section 1304 to fill the current jurisdictional gaps. Number 2, ensure and reaffirm that all 574 tribal nations can exercise criminal jurisdiction through VAWA. Number 3, reauthorize VAWA's tribal grant programs and create a reimbursement program for exercising tribal nations. And fourth and finally, create a permanent authorization for the U.S. Department of Justice's Tribal Access to National Crime Information Program. These 4 priorities build off of the 2013 VAWA reauthorization and further acknowledge the inherent tribal sovereignty and tribal jurisdiction to protect the safety and security of Indian country. In the 8 years since Congress reauthorized VAWA, we have seen tribal nations combat domestic violence against Indian women while protecting non-Indian rights in an impartial tribal forum. By exercising our inherent sovereignty and jurisdiction, many tribal nations have increased safety and justice for victims who had previously seen little of either. Currently, 28 tribal nations are exercising VAWA's special domestic violence criminal jurisdiction, and in 8 years, these nations have made 396 arrests, prosecuted 227 defendants, leading to 133 convictions. In 2016, the Department of Justice stated that these programs have allowed tribal nations to respond to longtime abusers who previously had evaded justice. It has also revealed places where the federal administrative policies, practices, resources, and tools needed to be strengthened to enhance justice for victims of sexual violence, children, elders, and law enforcement. Tribal nations report that children have been involved as victims or witnesses in nearly 60% of these cases. These children have been assaulted or have faced physical intimidation and threats, are living in fear, and are at risk for developing school-related problems, medical illness, post-traumatic stress disorder, and other impairments. However, federal law currently limits these cases to crimes against intimate partners or persons covered by a qualifying protection order. This common scenario reported by tribal nations is that they are only able to charge a non-Indian for violence against the mother and can do absolutely nothing about violence committed against the children. Similarly, tribal nations lack jurisdiction to charge a non-Indian offender for crimes that may occur within the context of the criminal justice process itself, such as resisting arrest, assaulting an officer, witness tampering, or obstructing justice. Tribal nations are also unable to prosecute crimes of sexual assault, trafficking, and stalking. In addition to the gaps, not all 574 tribal nations were included in VAWA 2013. Tribal nations in Alaska and Maine must be expressly included in this next reauthorization to protect their citizens and communities. Before I conclude my testimony, I want to share a case from the Sault Ste. Marie tribe of Chippewa Indians that illustrates how tribal jurisdictional gaps have real consequences. In the case, a non-Indian man in a relationship with an Indian woman moved in with her and her 16-year-old daughter on the reservation. The man began making unwanted sexual advances toward the 16-year-old daughter and groped her. The tribal nation charged him with domestic abuse against the mother and attempted to tie the daughter's sexual assault to the mother's case. The tribal court had no choice but to dismiss the charges for lack of criminal jurisdiction. Soon after, he kidnapped a 14-year-old Indian child, took her off the reservation, and repeatedly raped her. This horrific crime could have been prevented if the tribal nation had the ability to exercise criminal jurisdiction in the first place. removing the gaps in tribal jurisdiction, and ensuring all 574 tribal nations can exercise jurisdiction, and providing the resources and tools for implementation together can dramatically change the environment in Indian country by empowering tribal sovereignty and safety. Please join us in sending this message that domestic violence, sexual assault, child abuse, elder abuse, stalking, and trafficking will not be tolerated on tribal lands. We look forward to working with each of you to pass a bipartisan VAWA bill that includes strong tribal provisions. Sioquil.
Thank you very much. Chief Judge Forstar, please proceed.
My name is, good day, my relatives. My name is Stacy Forstar. I am the Chief Judge of the Fort Peck Assiniboine and Sioux Tribes. Thank you, Chairman, Vice Chairman, and committee members for holding this hearing today. I am providing testimony on behalf of the reauthorization of VAWA. Fort Peck has been implemented VAWA since March of 2015. Initially, we were one of 5 pilot tribes. Prior to 2013, we had consistently had reports of domestic violence of non-Indians on Indians being under prosecuted or not prosecuted at all. The crime is a domestic violence. It is a federal misdemeanor, and the federal government did not have the time to prosecute those crimes because of the major crimes that have been occurring on Fort Peck Indian Reservation. So since we've implemented VAWA, we have had many successes. We've had a couple challenges, but I want to highlight some of those successes through my testimony. We have had, I'm going to give you a little bit of stats and data. We've had 45 VAWA cases under special jurisdiction since 2015, with a total of 37 defendants. Defendants have, we have reoffenders and defendants with multiple charges. The criminal charges are partner family member assault and violations of permanent protection orders. The Fort Peck tribes have conducted 2 jury trials that consisted of Indian and non-Indian jurors, and we've had 2 acquittals from those 2 jury trials. We've had 9 guilty pleas on the record, and defendants have actually opted into diversioning programs that have been offered through the restorative justice measures that the Fort Peck tribes have implemented. Although we cannot prosecute crimes against children when they are involved with the domestic situation between a non-Indian and an Indian, we do keep the stats on that as well. So of those 45 cases, we've had 21 cases that involve children that we were unable to prosecute, but we could offer services to those families. We've also had 19 cases that reported drug and or alcohol use that were involved with the primary offenses. We've had reports of law enforcement that have been engaged with the non-Indian defendant and unable to prosecute those crimes as well. Some of the specific successes that we've had at Fort Peck, they have been funded through grant programs through the federal government. We have a SASA, a Special Assistant U.S. Attorney, who is primarily here to prosecute the domestic violent crimes, along with coordinating between the tribes and the U.S. Attorney's Office. We also have a public defender's office with an attorney on staff who is able to be appointed as counsel, effective assistant of counsel for the defendant, not only for non-Indians, but for Indians as well. And that was a change that we made along with our implementation. We also have grant programs that have funded DV data collection, software programs for case management. We have an offender accountability program. We have civil legal lay advocate services for victims and their families. And we've had a overwhelming response to the jury polls. We have a jury poll system that has been put in place along with the county representatives, and we've had great communication. We've had willingness of participation. So the jury trials do represent a fair cross-section of our communities on the Fort Peck Indian Reservation. Fort Peck Tribal Court maintains a website. In my testimony, it is fptc.org. And I would like you all to take the opportunity to look at that, to look at the tribal laws, to see what we have available, open to the public at no cost. The tribal state relationships that we have built and maintained along with VAWA have only begun to open up more opportunities for both jurisdictions, tribal and state. The Fort Peck tribes have had a successful cross-deputization law enforcement agreement in place since 1999. This agreement is with the County Sheriff's Department, the Montana Highway Patrol, and the City of Wolf Point, along with the Fort Peck tribal law enforcement officers. This agreement has allowed us to enforce each other's laws and to provide aid to one another. The agreement has also assisted with the smooth transition of the special jurisdiction on the Fort Peck Indian Reservation. Montana has established the first Native American domestic violence fatality review team. I would also ask that those of you please take a look at that and see the statistics that are overwhelming in Montana alone. In closing, I understand that authorizing the tribe's special jurisdiction over non-Indians is only one portion of the VAWA reauthorization, but it is a vital instrument to public safety and to effectively addressing domestic violence in Indian country. Now is the time to move forward collectively. Thank you. Namia.
Thank you, Chief Judge. Without objection, we'll include the data sets referenced in the record. And Professor Reese, please proceed with your testimony.
Kundawoha, thank you to the chairman and members of the committee for inviting me here to testify today. Navitoa Hawa Yompovi, Nabe Americana Hawa Elizabeth Reese, Nana Mea Winge Weang Mu. My name is Elizabeth Reese Yompovi, and I am from Nambe Pueblo. I hold degrees in political science and political theory from Yale and from the University of Cambridge, and a law degree from Harvard. I am now a law professor at Stanford, where I teach and write about tribal law, federal Indian law, constitutional law, and civil rights law. But I was asked to testify here today not only because of my academic expertise, but because of my professional experience. Before becoming an academic, I was an attorney at the National Congress of American Indians, where I worked closely with the first tribes who were implementing expanded criminal jurisdiction under VAWA 2013. I talked on a regular basis with the tribal prosecutors, judges, and defense counsel. I explained the intricacies of this law, its requirements, its limitations, more times than I can count. I tracked data from the implementing tribes and listened firsthand to the harrowing stories about what it was like to be on the front lines of those prosecutions. And then I took all of that and I wrote it up into the 5-year report published in 2018 that's been cited so many times today already. In my written testimony, I discuss at length many of the key takeaways from that report, including the need to increase VAWA's funding as well as its scope to other crimes against women. But in my remarks today, however, I'll focus on why it makes particular sense to expand VAWA to adjacent criminal conduct and respond to some concerns about the constitutional rights of non-Indians in tribal courts. To begin, currently, tribes cannot charge defendants with any of the crimes that happen alongside the domestic violent event that they are actually prosecuting, such as violence against children, drug possession, assault on law enforcement, or just a simple DUI that happens while fleeing the scene. An expansion to adjacent crimes would create a more equitable system for prosecutors and defense counsel to navigate. And that is because the vast majority of criminal cases in the United States are resolved not at trial, but by plea bargaining. And one of the most common tools that prosecutors and defense counsel have when negotiating a plea is that there are often multiple charges of criminal conduct. Taking a serious or minor offense off the table allows the two sides to arrive at a result that they can both live with. Without the full power to charge an offender with all of the crimes that they are suspected of committing, both sides are stuck with just that one offense, domestic violence. A charge which is notoriously difficult to prosecute in court because it relies on the cooperation of often highly traumatized and reticent witnesses. Violent crime is messy, and granting tribes the power to prosecute just one kind of crime simply doesn't reflect the reality of how crime happens or the tools that people in the criminal justice system need to do their jobs. Now, despite the truly unacceptable levels of violence against Native women, change has been slow, in part due to concern about the rights of non-Indians in tribal courts. And to that, I have two responses. The first is to clarify the law on this matter, since these concerns are rooted in several fundamental misunderstandings of the law. To begin, although the Constitution itself does not apply to tribal governments, the Indian Civil Rights Act, particularly as amended by the Tribal Law and Order Act and VAWA 2013, extends all of the relevant constitutional protections in a criminal court proceeding to non-Indian defendants. Congress created these protections and provided the powerful remedy of habeas corpus. As such, non-Indian defendants in tribal court already enjoy the same protection from unlawful detentions as they would in any other American court. Which leads me to my second response to those who may be worried about the fairness or adequacy of the justice system that tribes are running. And that is a simple reminder that tribal governments are American governments too, and that as such, they are no less worthy of our trust, respect, and dignity. Like any other government in this country, tribes are just a group of your fellow American citizens simply trying their best to do what is best for the people that they are responsible for. They are not perfect, but we ought to shy away from the continued unbefitting distrust of tribal governments as somehow inherently more suspect or less capable of dispensing equal justice. They, just like you, are trying in good faith to make and enforce laws that help people thrive and protect them from harm. It is high time that we trusted them to do that. I look forward to questions from the committee.
Thank you very much, Professor Reese. Last, we have Michelle Demeritt from the Director of Law and Policy Center, Alaska Native Women Resource Center in Fairbanks, Alaska. Please proceed.
Good afternoon. My name is Michelle Demeritt, and I am an enrolled citizen and the former Chief Justice of Central Council Tlingit and Haida Indian Tribes of Alaska Supreme Court and serve as the Law and Policy Director for the Alaska Native Women's Resource Center. The rates of violence experienced by Alaska Natives are shocking. Alaska ranks as one of the most dangerous places in the nation for women. This is especially true for Alaska Native women. While Alaska Natives comprise approximately 19% of the state population, the Alaska Criminal Justice Commission reports that 46% of reported felony-level sex offenses involved Alaska Natives. Given the many barriers to reporting, we assume this is an underestimate. Available data suggests that among other Indian tribes, Alaska Native women suffer the highest rates of domestic and sexual violence in the country. Alaska has the highest number of missing Indigenous persons too. As of August 2021, 40% of the missing Alaska Native and American Indian people in NamUs were from Alaska. These deaths, these missing women, are the devastating manifestations of centuries of oppression and broken systems that have failed to protect Native women and children from birth to death for generations. The combined impact of Public Law 280, the Supreme Court's Venati decision, and the timing of historical events in Alaska leave us Natives dependent on the state for public safety and justice. My written testimony discusses the legal framework in Alaska. Today, I will focus on what this legal framework means for Alaska Natives. It can be difficult to understand a place in America where you cannot call 911 for a quick response within minutes. Such is the case in Alaska. We do not have a centralized 911 system, and the state criminal justice and victim services are located in a handful of urban areas, making them more theoretical than real in rural Alaska. Many villages lack law enforcement. We might have to leave a message and wait hours, days, and sometimes weeks for a necessary response. Sometimes the response is nothing more than a phone call saying that it doesn't rise to the level for an investigation. Because we lack the necessary resources and infrastructure to manage these issues on our own, our children are often our first responders, and our tribal leaders and advocates act as law enforcement and preserve crime scenes. I'd like to share 2 examples. In a homicide case, it took 11 hours for law enforcement to appear. The 13-year-old victim's body laid outside across the street from the family's home. Sometimes these crime scenes are like this for days on end. We have lost our loved ones and are powerless to do anything more than sit vigil protecting a crime scene until law enforcement arrives. In a 2018 case in a small, remote interior village, a victim waited 17 days to get out of the village to safety. During this time, the victim was treated at the clinic and called Alaska State Troopers located in a hub community 1 hour away by plane. The weather was unflyable for 3 weeks. In addition, she could not get to a regional medical clinic for further treatment, and law enforcement could not get into the community for an investigative report. The circumstances described are repeated throughout remote Alaska. They will continue until our local governments have the authority and resources they need to address public safety. As you have heard, many tribes outside Alaska have successfully exercised jurisdiction over non-Indians who abuse Native women since the passage of VAWA 2013. Indian tribes in Alaska were effectively excluded from that legislation because of the use of the term Indian country, which Alaska tribes lack. We have called on Congress to remove the legal barriers denying Alaska Native victims of violence access to justice from their own tribal governments, and we are encouraged by current efforts to do so. We support the creation of a pilot project in Alaska. Specifically, we recommend the creation with Department of Justice support of an Alaska-specific intertribal special domestic violence court jurisdiction working group, a planning phase with robust technical assistance for code drafting, training, and court capacity building, and sufficient financial support for costs related to both planning and implementation. We strongly support proposed amendments to VAWA 2013 related to improvements for a special domestic violence court jurisdiction. Thank you. Thank you for releasing the discussion draft today. It represents an important step forward, and we appreciate the bipartisan work of the chairman and vice chairman, Murkowski, to reform the outdated federal laws that prevent tribal nations, including those in Alaska, from protecting our communities. In the Tlingit language, we had no words or descriptions for violence within a family home. Restoring and enhancing local tribal governmental capacity to respond to violence against women provides greater local control, safety, accountability, and transparency. As a result, we will have safer communities and a pathway for long-lasting justice. I look forward to providing additional feedback to the committee on the discussion draft. Gunesh Chish, VAWA. Thank you.
I've been in politics for more than 20 years now. I've been to a lot of hearings. This was maybe the most impressive panel that I've ever heard. So I want to thank each of the individual testifiers for their clarity, for their advocacy, and for helping us to build the legislative record. Mr. Garriott, can you talk about cross-deputization? And by the way, I'm going to ask a lot of questions, so I'd like everybody to be as brief as possible. Talk about cross-deputization, how it works, and why it seems to be increasing as a practice.
Thank you, Chairman. Cross-deputization, as many know, there is a maze that is incredibly difficult to understand and even more incredibly difficult to implement for law enforcement around jurisdiction. On one side of a line, depending on the victim, depending on the jurisdiction, depending on the perpetrator, it might be tribal jurisdiction. On another side of the line, it might be state jurisdiction. Cross-deputization allows tribes and state law enforcement to be deputized in another jurisdiction so that they can eliminate those jurisdictional gaps. It is a practice that is gaining more and more increased use by tribes, and I think that is an incredible testament to the effectiveness and the solutions that it can offer.
Thank you very much. Ms. Randall, we know there have been 0 valid habeas corpus petitions filed and 0 due process claims since 2013. Just tell me, has special jurisdiction been a success?
Absolutely, Senator. It's been a success for those individuals who have finally gotten the justice that they need, as well as for the communities that can, interrupt perpetrators who may have been acting with impunity. And significantly, it's been a success in protecting defendants' rights as well, as you noted, with no valid habeas cases, as well as, the rates of acquittals and dismissals show how careful tribes have been with implementation. And that's why this committee, must expand recognition to other crimes.
Thank you. And a follow-up on this issue, Professor Reese, just for the record, is special criminal jurisdiction constitutional?
Thank you. So absolutely. So I think that when I'm asked that question, I think about it on 2 levels. First, whether or not Congress sort of has the power to do this. And the answer to that question is absolutely, Congress has the power to do that, especially since the Supreme Court decision in United States versus VAWA affirmed that tribal sovereignty is inherent and that Congress has the ability to reaffirm the existence of inherent sovereignty by passing legislation which reauthorizes tribes to exercise a power even that they previously were not authorizing based on a Supreme Court decision in this case, and also in Lara Oliphant. So absolutely, you have the power to do this. And as similarly discussed in Lara, the only other questions would be if it implicates any other constitutional rights concerns. But we've known for several hundred years now that the Constitution does not apply to tribal governments in the same way. So that is also not an issue. But going above and beyond that, Congress has also created equivalent constitutional rights protections through this statute. So those sort of underlying concerns are also protected and incorporated into this law, even though that constitutional question itself isn't really implicated.
At the risk of being redundant, I want to ask you to, really make this point as clear as possible to anybody who's watching this hearing, what the Indian Civil Rights Act does for defendants and for the justice system in Indian country, because you mentioned in your testimony, you're referring to it now, but I think it's a really key point as it relates to due process as a matter of principle and as a matter of law. And I'd like you to just flesh it out just a little bit.
No, absolutely. So it guarantees a long list of equivalent protections that are guaranteed to the rest of the citizens of the United States in courts of law. So I'll go ahead and just list out these protections that the Indian Civil Rights Act, the Tribal Law and Order Act, and VAWA 2013 sort of when combined guarantee to non-Indian defendants. So that includes the protection to the basic right to due process of law, the freedom from an illegal or warrantless search or seizure, the prohibition against double jeopardy, the right against self-incrimination, the right to a speedy trial and confront witnesses, the right to a jury trial, the right to indigent defense, the right to effective assistance of counsel, the prohibition on bills of attainder, the right to not be subjected to cruel or unusual punishment, excessive fines or fees. Like, this is the entire gamut of the things that the Constitution does to protect the rights of defendants when they're being prosecuted for a crime. Like, that is the full list of things that was written up into this statute to protect non-Indian defendants in this court system. And anytime that one of those things, if it were to happen, results in an unlawful detention or incarceration of someone, they are protected by the writ of habeas corpus.
Thank you very much. My final question before an additional round, Mr. Garriott, we've heard about the high cost of implementation. I'm just wondering what the department is doing to assist tribes in implementation. All of this is great as authorizing language, but it does seem to me, it's obvious to me that it's a resource question too. It's a how do you cover the jurisdictions that are so vast? I'm thinking about Alaska in particular, but really Indian country everywhere. You have this problem of staffing, of having a person on the ground. How do you help? How can you help?
Chairman, thank you for the question. And as you've touched on, the resources is an issue and a challenge that we hear all the time from our tribal partners and those that we work with on the ground. Thus far, since 2019, we have funded 115 tribal court positions, which includes tribal judges, prosecutors, and other court personnel across the country to help tribes have some of the resources they need on the implementation side. I would also point to our FY 22 budget request, which is a total of $507 million, which represents an increase of $58 million over the FY 21. A big part of this budget request puts boots on the ground, and it will begin assisting tribes to better provide law enforcement for their communities and better protect their citizens.
Thank you very much. Senator Cortez Masto.
Thank you, Mr. Chairman, and to the ranking member. I cannot thank you enough for having this conversation today on such an important issue. It is so clear that the Violence Against Women's Act needs to be passed, and the special domestic violence criminal jurisdiction is essential to protecting our Native communities. I strongly believe that Congress must not only reauthorize VAWA, but strengthen it to ensure that tribes can effectively prosecute crimes against women, children, and law enforcement in Indian country. So I'm going to focus my questions around that. But I want to follow up on what Chairman Schatz started with. Let me ask this question. President Sharp, how many more tribes do you think would be interested in implementing special criminal jurisdiction if they had the resources and support that they needed to do so? I'm curious if you have an answer for that.
Yes, I would say out of the 574 tribal nations, the remaining, which is hundreds of tribal nations, would be interested if we had the resources.
Right, and my understanding is there's only, is it 28 now that have the ability?
Yes.
Okay, so we need more. We need to do more. So let me ask you this. You heard what the Principal Deputy Assistant Secretary said, Garriott. Do you think, based on the resources that he says are available, that that's enough? And what more should we be considering in Congress to provide the resources that are necessary to give more of our tribal nations across the country the opportunity to protect their own?
Yes, in just listening to his response, I mean, clearly we don't have even close to the scale of resources necessary to implement the spirit and intent of what Congress is trying to accomplish here. And one could only look to the U.S. Commission on Civil Rights report called The Broken Promises that was delivered to Congress almost 3 years now. And they detail not one federal agency is living up to its trust responsibility. We are woefully and chronically underfunded across every sector, including our criminal justice system. So we definitely have a large scale need in Indian country to implement VAWA.
Thank you. And Ms. Demert, in your testimony, you mentioned that children have been involved as victims or witnesses in special domestic violence criminal jurisdiction cases nearly 60% of the time. To me, that is just unacceptable that children are falling through the cracks of laws meant to combat violence in Indian country. So when it comes to the safety and the health of our Native children, how important is it for Congress to expand the current special tribal jurisdiction to cover more crimes? Can you talk a little bit about what crimes that are not covered, that in essence are where our children are victims, that we should be looking to protect their interests?
Thank you for the question, Senator Cortez Masto. And I don't believe I said that about children. I said children are our first responders, but fortunately, I did work for a tribe that implemented domestic violence jurisdiction back in 2013 as one of the first 3 tribes. And in that, our children were, in our first year, I think we had 11 cases. And 9 of those cases, children were victims of violence. And in one case, we had a child who was trying to get, as a first responder, trying to get the father off of her mother, and the child was tossed aside and had to, I believe, probably called for the police. But these are that's just an example. All of these cases frequently involve children being present and being participants of the violence that's committed against the mother. In another case, we had a case where the mother was held hostage for a few days, and a knife was being thrown at her, and he made her, the mother, hold the victim, or hold a child in her arms while he threw knives at her. And fortunately, that case ended up being picked up by the U.S. Attorney's Office. And so the child did see justice. But in so many other cases, there is not justice. And in Alaska in particular, I just want to bring it back to that. Our children are the first responders, have to call for help. And we don't have law enforcement. Often we have volunteer medics. And so the parade of horribles are horrible, but we have beautiful communities that we want to protect and safeguard. So goodness sheesh for the question. I hope I answered it.
You did. Thank you. Let me talk a little bit, and you touched on this as well. I know from my time as Attorney General that domestic violence calls are some of the most dangerous calls that police officers can respond to as well. And Director Randall, your testimony discusses the very real safety concerns that tribal law enforcement officers have when they're responding to these kinds of calls. So right now, what happens if a tribal officer is responding to a domestic violence call and the non-Indian suspect attacks the officer?
Well, without jurisdiction, the federal government must respond, and this can really empower perpetrators to commit acts of violence, knowing that a federal response could be hours away. In the case of Alaska, responses could be days away. And as you note, these are dangerous calls for law enforcement officers, and this is a crucial part of VAWA to include.
To include coverage or protection.
To include coverage of protection.
Correct?
Absolutely.
Yes, thank you. And then, Secretary Garriott, your testimony mentions that expanding tribal criminal jurisdiction beyond domestic violence crimes would be a significant step toward ending the crisis of missing and murdered Indigenous women and children. Can you talk a little bit about this? How reauthorizing and strengthening VAWA will help ensure we are using all of the available tools that we need to keep Native women and children safe?
Thank you for the question. This is an issue that is of particularly concern and is very important to the Secretary and to the Department. Expanding criminal jurisdiction to cover a wide variety of crimes, as we've heard, is incredibly important, not only for children and for law enforcement, but also expanding the crimes to include not just coverage of protection orders and domestic violence, but sex trafficking and other dating violence and other crimes as well. As we know, there is no one simple kind of crime, and that we need to have full coverage to ensure that our tribes, our law enforcement officers, children have full protection.
Thank you. And thank you. Again, this is an incredible panel. I so appreciate your advocacy on such an important issue that needs to pass Congress. Standing in for the chair, I am going to call in, I understand Senator Smith is next, and she is joining us virtually.
Yes, that's right. Thank you, Chair Cortez Masto, and thanks to all of you. I am just so grateful for this important panel. I want to start by thanking Chair Schatz and Vice Chair Murkowski for your work on this bipartisan agreement to reauthorize the tribal provisions of the Violence Against Women Act. And I also want to thank them for including my Justice for Native Survivors of Sexual Violence Act, which would expand tribal criminal jurisdiction to include crimes of dating and sexual violence, sex trafficking, stalking, and obstruction of justice by non-Native offenders on tribal lands. The many conversations I've had with folks in Minnesota have convinced me that this measure is really essential to addressing the crisis, really the epidemic of violence against Native women. So I'd like to focus my questions on that, and I'll start with you, President Sharp. It's so good to see you again, even virtually. We, of course, both know that more than 4 in 5 Native women experience violence in their lifetimes, and many of them are victimized by non-Native offenders. And this ongoing crisis of missing and murdered Indigenous women and people across the country is so severe. I believe that this My Justice for Native Survivors of Sexual Violence Act, which is included in this bipartisan agreement, would help to address this. So could I ask you to speak to that? Could you talk to how that expanded tribal jurisdiction would help tribes to address the crisis of missing and murdered Indigenous women? And I want to just say, since I have been running around today, forgive me if I'm asking a question that is repetitive of others' questions, but I really want to have a chance to visit with you about this.
Yes, absolutely. And first of all, I want to thank you for your leadership and your ability to see from our perspective the real threat that all of these issues that you're seeking to address mean to us. It's quite remarkable to have someone with your level of advocacy around such critical issues. So yes, this would definitely go a long way to help. And the way in which it would help the missing and murdered Indigenous women's crises, I think it's important for everyone to understand our women and our girls are being targeted by perpetrators. They know there's a weakness. They know there's a void, a jurisdictional void. And so those girls who are targeted for trafficking, those women who not only have dating relationships, but absolute strangers that come onto tribal lands, as well as law enforcement who seek to protect them. These provisions would ensure that those gaps in our missing and murdered Indigenous women's crisis would be met, that we would be able to fill those gaps and ensure that we have justice in these critical areas, because we are being targeted. So thank you for your leadership and recognizing that and trying to help solve that with us. Siokwill.
Thank you. I think people don't realize the extent to which Native women live in a justice-free zone where they are targeted. It is no accident. It is a feature of our system that Native women are targeted in this way, and it is our obligation, our moral obligation, to address that. And so I appreciate your comments. Governor Chavarria, it is good to see you. As a New Mexico-born senator, I am so happy to see the visual behind you as well. So greetings to you and everybody at Santa Clara. I was wondering if you could talk about how the expanded jurisdiction your tribe implemented has helped you to address the crisis of missing and murdered Indigenous people. And could you comment on how the expanded jurisdiction in this bipartisan agreement would help to further address this challenge?
Well, thank you, Chairman, members of the committee. Thank you, Senator. I appreciate that question. I think what's very important is that we have to recognize that the VAWA reauthorization, when it expired, we needed a permanent authorization, as was mentioned by the witnesses here, to expand that tribal jurisdiction over the crimes against our children. Here in Santa Clara, we have multi-generations living under one household. That includes grandpa and grandma. And also law enforcement personnel. Sexual assault crimes committed by strangers to provide increased safety and access to that justice services for victims of crime is very essential. So it is important that all the discussions happening today will help fulfill the life, safety, and welfare of our entire community within our public communities. Without that, it makes it challenging. And so you have that opportunity right now to help us within our judicial system, our law enforcement, but also as a tribal government to implement this for the life, safety, and welfare of our entire community, Senator.
Thank you very much. And I want to just say how grateful I am to Senator Ben Ray Lujan's leadership on this issue as well. I don't know if Senator Lujan has had an opportunity to ask his questions yet, but I want to nod to his leadership. We're so grateful for him. Madam Chair, I will yield back if you have others in line. I have one other question if you don't.
I think we have a full slate, Senator Smith. We've got a lot of interest in this, so thank you. Appreciate it.
Thank you.
Thank you. I'm going to jump in here, if I may, as I am next in line. And this is directed to you, Michelle. Thank you for, again, your ongoing leadership, and not only over the years, but over the decades as you are working to protect vulnerable Native women throughout the state of Alaska. We've heard continuously here about the gaps that need to be addressed, and I think there is no better area to look at the chasm that exists when it comes to the inability to currently protect people in so many of our Native villages. But you have some unique experience within the DOJ Intertribal Working Group for the lower 48 tribes. So you've had an opportunity to observe down in the lower 48 and then extrapolate how we can make things better in Alaska. Resources obviously are important. Funding is important for training. Funding is important on so many levels. But is it what more can we be doing specifically in enhancing our efforts? Is it supporting the intertribal participation in the pilots to accommodate economies of scale? Is it building the cross-jurisdictional collaboration? I'm kind of second guessing that it might be all of the above, but if you can speak to what more we can be doing specifically to address these gaps here in Alaska, there in Alaska.
Gunishish Ansha Waku, Vice Chairman Murkowski, we so appreciate your leadership in this bill, as well as other important bills such as the boarding school bill. As to your question, thank you so much for it. It is all of the above. Think about it. Since statehood over 60 years ago, Public Law 280 has been in effect, meaning the state has had jurisdiction. And what has happened? We, as Indigenous women, have been horrifically unsafe. We have some of the worst DV rates, the worst murder rates, the highest missing Native rates, and our victims are too often left without any justice, or it is delayed in that it re-victimizes us. I'm a survivor of childhood sexual assault from someone that was abused in boarding schools. The state has had 63 years to show their competencies. Give us time and similar resources. Don't tie our hands. We have beautiful communities, beautiful traditions, and deserve better. We are state and federal citizens in addition to our tribal citizenship. Principal Deputy Director Randall explained in her testimony how successful the ITWIG is. The tribes can exchange views, information, and advice about how they can best exercise special domestic violence court jurisdiction, combat domestic violence, attend meetings, webinars, share ideas, material challenges, and best practices. The ITWIG I participated in as a point of contact for one of the first 3 tribes was a wealth of information, and Virginia Davis at NCAI and others like her were amazing. The support they provided and the dialogue that we exchanged was simply one of a kind and should be replicated whenever possible. Goodness geesh, Hawa, Senator Murkowski, you are just so appreciated.
As you are, Gunesh Jish. Let me direct my next question here to our Principal Deputy Assistant Secretary Gariat. It was good to see the BIA dispersing about $30 million to tribes in PL 280 states, even though BIA doesn't execute the 638 contracts and the compacts for public safety and justice. So what I'm hoping to learn is how we can navigate some of these roadblocks to public safety and access that we have in Alaska, recognizing that we are a PL 280 state. Is there some kind of an internal policy out there that doesn't allow BIA to receive public safety and justice funding in states like Alaska that are PL 280? I'm trying to figure out this funding piece of it, because in addition to serving on the authorizing, I'm also on the appropriating side of this. So help me out.
Absolutely. And thank you, Vice Chairman. And as somebody who's been to Alaska several times, I understand a lot of the unique challenges, and it's good to see my home state senator. I thought I knew rural coming from South Dakota, but it's a different ballgame up in Alaska. And as you noted, resources are a challenge. One thing that I would point to is that there is a line item within our budget that is specifically reserved for funding Public Law 280 court systems. In 2019, that was funded at $13 million, and in 21, it was funded at $15 million. In addition to that, we continue to provide training and technical assistance to assist Native villages in standing up their own court systems. Right now, about 130 of the 229 villages have court systems, and we're looking to continue our work to help those villages stand up their court systems.
I'll have further questions, Mr. Chairman. Thank you.
Senator Cantwell.
Thank you, Mr. Chairman. I definitely want to thank you and Senator Murkowski both for holding this important hearing
Washington State has one of the highest numbers of murdered and missing Indigenous women, and definitely always applaud the Seattle Indian Health Board for their work on this, and my colleagues who are here today who have fought so hard on this, getting legislation implemented. I think we're here because we still see the crisis, and we still see that we are, I think the issue is short of resources. I think that what we're saying is we've identified this problem. We want to do something about it. We've put some resources on the table, but I think we're now finding that the resources are not enough. So I would like to hear from Ms. Randall. Definitely want you to come to Washington State, if you will, and meet with our various law enforcement communities. But I would like to hear from you and NCAI Chair President Von Sharp about what is the real crisis at hand. Is it resources? Is it the tribal court system? What is it that we need at this moment to further accelerate helping to protect women in Indian country?
Thank you, Senator, and I would be honored to visit and sit with folks. The Department of Justice sees the need for really broad response to MMIP, and after the Tribal Nation Summit, our Deputy Attorney General set up a steering committee across DOJ that will include both grant making and prosecution, because we need that holistic response. It's also important that when we're talking about tribal problems, that we are meeting them with tribal solutions. And so consulting with the tribes has got to be a really key part of making important and strategic decisions going forward. We are coordinating, of course, with the Not Invisible Commission and bringing, I think, significant resources to bear. The department has requested additional funding in the president's budget, and we look forward to our work together to identify strategic, specific resources.
So, President Sharp.
Yes, good to see you virtually, Senator. Thank you for the question. I think you raised an important connection. When you consider missing and murdered Indigenous women and the boarding school crisis that we're seeing, as well as these issues of violence against our women and girls, it's all related. It's generation after generation of tribal nations not only not securing the resources that the United States should uphold pursuant to treaties and its trust responsibility, but our own inability to raise revenues through systems of taxation. And as we are entering a sort of a post-COVID time of redefining our economies and trying to restore our economies, it's critically important that Congress consider not only supporting and honoring our treaty and trust responsibility, but the economic agenda that tribal nations see for providing the resources that we should be doing as an attribute of our inherent sovereignty. And we have all kinds of recommendations related to tax policy, economic policy, international trade related to green and renewable energy. Indian country is a target-rich environment to unlock an economy, but we just need the support of Congress. Thank you.
Thank you for, and I'm assuming you're referring to the issues of, prosecution on tribal reservations, but there's nothing that's holding us back from larger prosecutions of these crimes involving that aren't actually occurring on the reservation land. Is that correct?
That's absolutely correct. Yes.
Ms. Randall, do you have a comment about that?
Well, I can't comment on any ongoing prosecutions. I know that my colleagues at the Executive Office of the U.S. Attorneys have been investing significant resources into these cases.
Well, I think the reason, I haven't drilled down on every detail, but I'm pretty sure the reason why the Seattle Indian Health Board did this study and analysis is because, and we have one of the highest rates of missing and Indigenous women, is because it's right there in Puget Sound. And they just happen to be very large percentage of them Alaska natives. So this is a population that doesn't live on tribal land, and yet they have become victims of these horrific crimes. And so I would love you to come to Seattle. Maybe Senator Murkowski and I will join you, and we'll do something to bring focus to this. But separate, we definitely get the separate issue because we've all been involved with VAWA and the more empowering of DOJ working with Indian country on tribal courts and that process to make sure that federal law is enforced on Indian country land. We get that. But for us, this is, is a multi-pronged issue in, again, obviously impacting non-Native American women as well. And being on a corridor like I-5 helps accelerate some of these problems. So we would love to figure out ways to go take the next step here and get the enforcement of this law. Thank you, Mr. Chairman.
Thank you, Senator Cantwell. Senator Hoeven.
Thank you, Mr. Chairman. Deputy Director Randall, in your experience, how have the provisions included in the 2013 reauthorization of VAWA been beneficial for tribes?
Yes, Senator. They have been beneficial by allowing tribes to, often hold repeat offenders accountable. Tulalip has an example where the perpetrator had 19 prior contacts with tribal police before SDVCJ is passed. So this helps keep the whole community safe, in addition to finding justice for those survivors.
Under the 2013 VAWA, what's covered under the SDVCJ? What does that include?
Domestic violence, dating violence, and certain protection orders.
And are there areas of criminal jurisdiction that you believe should be expanded for tribes, and if so, why?
Yes, Senator. As we have heard so compellingly today, crimes that occur often in conjunction with domestic violence, such as crimes against children, are crucial to be able to prosecute. Also, sexual assault, sex trafficking, assault of law enforcement.
Thank you. Assistant Secretary Little Elk Garrett, I understand that there are currently 28 tribes that have implemented VAWA, Special Domestic Violence Criminal Jurisdiction, SDVCJ. In your experience, what considerations does a tribe undertake when determining whether to elect this jurisdiction?
Thank you. When a tribe decides to assert this jurisdiction, there are a number of provisions and actions that it has to take from its standpoint, including making sure that its law and order code is in place and that it meets those requirements, and that also it has access to the resources that it needs. And our part at Indian Affairs really focuses around technical assistance in training to assist those tribes in standing up their court systems so that they can implement those provisions.
Why aren't there more tribes that have adopted this jurisdiction?
Anecdotally, we can say that it's a large undertaking, and that again, ensuring that when a tribe makes this decision, that they have the resources, also the political will, and assuring that they're feeling comfortable from a tribal government perspective to stand this up, that their court is fully staffed and has the adequate resources that it needs.
So is it primarily resources, and do you expect more tribes to do it?
Resources is definitely a challenge. We have continued to provide training, and there's been a tremendous response. We've provided training to over 3,300 participants. And that there are a number of tribes that are contemplating this. I don't have the exact number, but I think as we've heard some of the other witnesses eloquently discuss, there is a definite and strong desire for tribes to begin going down this road and asserting their inherent jurisdiction.
For Governor Chavarria, as a tribe that's implemented special domestic violence criminal jurisdiction, could you talk about your tribe's experiences with the implementation?
Thank you, Chairman, members of the committee. So for Santa Clara Pueblo, we opted in because for generations, we recognize the damage done by domestic violence. And what's very critical to understand, Chairman, Senator, is that it makes our tribal court into a federal court system. So because of those reasons, it took Santa Clara a number of years to implement VAWA, because we had to adopt certain measures to take concrete actions to meet the federal standards for implementation of VAWA. These were administrative, burdensome, and costly to undertake. And so one example is that you had to implement standards for updating our facilities. Unfortunately, Senator, we had a mobile home and it was mice infested. So we had to reach out to the Department of Justice, Office of Tribal Justice, and Bureau of Justice Administration for some funds to renovate and expand our courthouse. So the facility standards that we had to meet in order to implement VAWA was we had to have a secure, healthy facility with closed files, a detention room for alleged offenders, expand our public seating, a community education room, a jury box, a jury deliberation room, modern recording devices, fire and safety upgrades, and disability accessibility. And so those are the reasons why it does take time and challenging for tribes to implement this because of the issue to include federal funding. Without federal funding, it's very important because we had to use funding to hire legally trained prosecutors, defense attorneys, again, build these facilities so that we are meeting that federal requirement of turning our tribal courthouse into a federal courthouse to implement this very important initiative to protect the life, safety, and welfare of our entire community, Senator.
Thank you, Governor, and that's a very striking background you have there. I just wanted to compliment you on it. Thank you, Mr. Chairman.
Senator Lujan.
And Mr. Hoven, we'll invite you to New Mexico, sir. We'll take you there personally. So with your permission, Governor, we'll do that. I look forward to getting you out to New Mexico, sir. Appreciate that, Senator. I was proud to introduce the Native Youth and Tribal Officer Protection Act to provide more support and authority under special domestic violence criminal jurisdiction over non-Indians in domestic violence situations involving children and tribal law enforcement. The bill will help pueblos and tribes like Santa Clara make their communities safer and reduce violence against their most vulnerable members. Governor Chavarria, yes or no, is it true that the Pueblo still cannot prosecute crimes against children and tribal law enforcement officers when non-Indians commit domestic violence?
Yes, Chairman, members of the committee.
And Governor Chavarria, yes or no, is it true that neither the state nor federal law enforcement authorities prosecuted a domestic violence case on the Pueblo when a non-Indian assaulted a responding tribal officer?
Yes, Chairman, members of the committee.
And Chief Judge Forstar, yes or no, does the Fort Peck, Usanboyne, and the Sioux tribe had domestic violence cases come before tribal courts that they could not prosecute because of limited VAWA jurisdiction over children and tribal officers?
Yes, that is true.
And Governor Chavarria, yes or no, would you agree that legislation is needed to expand special criminal jurisdictions for tribal courts to be able to prosecute non-Indians that commit domestic violence crimes on tribal lands against children and tribal law enforcement?
Yes, Chairman, members of the committee.
Governor Chavarria, yes or no, did your Pueblo need to seek additional federal funding outside the VAWA grant program to meet federal standards to implement special criminal jurisdiction?
Yes, Chairman, members of the committee.
And Professor Reese, would you agree that additional federal funding is critical for tribal public safety generally, and particularly for tribes that opt to exercise VAWA, special criminal jurisdiction?
Absolutely.
And Ms. Randall, yes or no, in tribal consultation, have tribes cited the need to amend VAWA to increase funding to exercise special domestic violence criminal jurisdiction and help more tribes participate in the program?
Yes, they have, Senator.
And President Sharp, the 2018 NCAI report on 5 years of special domestic violence criminal jurisdiction notes that implementation of the law revealed serious limitations in the law. President Sharp, yes or no, does the report note that current statute prevents tribes from prosecuting crimes against children and law enforcement?
Yes.
And President Sharp, yes or no, do you believe expanding tribes' ability to prosecute crimes against children and tribal law enforcement is a needed expansion of the 2013 VAWA law?
Yes.
And Governor Chavarria, I wanted to give you a minute or so just to explain some of the additional challenges that you have faced that you hope that additional VAWA legislation or reauthorization should be able to cover.
Chairman, members of the committee, yes, and for a long time, Senator, we recognize that the damage of domestic violence. And so without the federal aid and protection from funding to build up our internal capacities to protect our law enforcement officers, grandma, grandpa, the entire household, to include myself. As a tribal governor, I also respond to these calls because it impacts our entire community. And so it's very critical, Chairman, members of the committee, that we expand the current VAWA to include all the officers, tribal officials, our children, grandpa and grandma, to include our tribal court system, to having that jurisdiction to prosecute these non-native offenders within our tribal court system. We cannot have a lawless community because it hurts all of us. And so this is very critical, Senator, that we continue to help you to look at, to include the Indian Civil Rights Act, the domestic violence section, again, mandates requirements that are costly. With the support of federal funding, Santa Clara Pueblo is undertaking the training of the victim advocates, law enforcement, prosecutors, and public defenders. So with that said, Senator, members of the committee, additional federal funding is critical so that we can meet these challenges to implement this to the full standard, Senator.
Thank you, Governor Chavarria, and thank you, Chair. I yield back.
Thank you. Senator Daines.
Chairman Schatz, thank you, Vice Chairman Murkowski, for holding this very important hearing on the Violence Against Women Act as it relates to the tribal provisions. Is a topic of great importance for so many Montanans, including myself. Thank you, Chief Judge Forstar, Fort Peck, for joining us from Poplar, Montana. We have a couple other great Montanans here today from Fort Belknap. I see Terry Brocky back there, and I think it's Tuffy Helgeson back there if I can see him behind his cowboy hat. But welcome. Good to have you here. I will tell you, first, before I make the rest of my comments and ask my question, I am proud to sit here as a supporter of the VAWA reauthorization of 2013. I remember having women from Indian country coming into my office and sitting down and telling me their story that was very persuasive and helpful in coming to my own decision to vote in favor of the VAWA reauthorization of 2013. I think VAWA has been a critical piece of legislation in combating missing and murdered Indigenous women crisis. In fact, I'm encouraged by the bipartisan work that's being done in the committee and the current direction of the negotiations. It's been hung up a few times, and I think we've got to get these tribal provisions right, and I think we're headed in the right direction. But that said, I will tell you it's disheartening to see some partisan politics going on with the underlying bill and to push an unconstitutional version that was passed by the House. Democrats, by extension, are holding up any hope at a bipartisan deal with the underlying bill by pushing it and pushing an unconstitutional version that was passed by the House. The reason is because there are provisions here that will attempt to strip Montanans of their Second Amendment rights. The larger package that passed the U.S. House in March contains language that would stifle Montanans' right to keep and bear arms. The current conversation circulating around VAWA includes President Biden's unconstitutional gun control agenda surrounding the so-called boyfriend loophole. As H.R. 1620 shows, the apparent cost of closing this new loophole is to, number one, enact retroactive lifetime gun bans for misdemeanor offenses, two, create federal ex parte gun bans, and three, fund and train police agencies to seize guns from these new retroactively prohibited gun owners. Should a misdemeanor stand as the line crossed for an individual to lose a constitutional right? That's an important question. Should Americans be deprived of a constitutional right without first facing their accuser in a court of law? This current language would essentially create red flag gun confiscation orders in states that have never passed one by adding an ex parte gun ban to restraining order laws, meaning an individual could lose their right to bear arms without even knowing it. On top of that, this bill subsidizes the prosecution of misdemeanor gun bans, and the enforcement of these newly co-opted gun confiscation laws. We don't need more infringements on the right to keep and bear arms. We need to restore it. There was a recent Wall Street Journal article just from September. About 50% of new gun buyers are women. Historically, it's been about 10 to 20% for decades. Until the last 2 years, 50% approximately of all new U.S. gun buyers are women. There's a reason for that. They want to be able to protect themselves. Women do not need more gun control. Gun rights are women's rights. Yet my colleagues are using an important piece of legislation I believe is a Trojan horse for gun control legislation that otherwise would never, ever be passed. It's imperative that we as a legislative body put some of these pet projects aside. Let's remove this language from VAWA and get back to the bipartisan nature of the conversation and negotiations, and let's get VAWA reauthorized again. Chief Judge Forstar, what are some of the biggest challenges combating violence against women in Indian country?
The challenges that we've experienced at Fort Peck is
Chief, I think we've lost your sound.
I'm unmuted. Can you hear me okay now?
Yeah, we can hear you fine. Thank you.
Some of the challenges that we've experienced at Fort Peck is incarceration. Incarceration that may be justice to some, but not to all. So Fort Peck has looked at other alternatives. We have our own jail. It is a 638 program. It is a tribal jail, but it is facilitated for long-term incarceration. But with VAWA, it isn't so much incarceration that seems to be the forefront of what our victims are telling us as they're coming in. It's restorative justice, it's rehabilitation, because they all remain members of the community and they have families and they want the family unit to remain together. So that's why we have focused on more of the alternatives to sentencing. But the challenge that we did have at the very beginning was medical costs for those that were incarcerated. It wasn't the issue of incarcerating or providing for them. It was just the medical costs that came with pre-existing health conditions prior to them being in our custody. But as some of the other members have mentioned, funding is always an issue. But I have to say at Fort Peck, funding wasn't the issue for us because we had already started with the Tribal Law and Order Act and becoming compliant with that. So we already had a lot of those effective assistance of counsel, attorney prosecutor. We had a lot of those in place. So it was just a matter of how fast we can move with it. Thank you, Senator.
Yeah, Chief Judge Forstar, thank you. Thank you for your service there in Poplar. And also for your continued progress in the 638 transition. Chairman Schatz.
Senator Rounds.
Thank you, Mr. Chairman. First, I want to thank all of you for being with us here today. And I'd like to especially thank our distinguished witness from the great state of South Dakota, Principal Deputy Assistant Secretary Little Elk. It's good to see you, and I'm very pleased to see you here with us today. I look forward to hearing about your experiences and your insight into how VAWA has impacted our tribes and Native communities in South Dakota and elsewhere as well, as you've been here and learned. My first question, though, is for Chief Judge Forstar. I understand some reauthorization efforts for the Violence Against Women Act have discussed the value of expanding tribal jurisdiction over non-members for additional crimes. In your experience presiding over cases in your tribal court system, would expanded jurisdiction help or hinder your tribe's capacity to handle an increased caseload?
Definitely help. To expand it to include children, law enforcement, we've even talked about drugs and alcohol. And it's to be able to provide the services that are needed for the offenders the victims, and all of those that are affected by the crimes. With the expansion, it wouldn't put any undue hardships on the Fort Peck tribes. It is just going to elevate what we can do for our communities, because at the present time, although we can provide services, we can't necessarily provide the defendant with the offender accountability that they may need in regards to what has been occurring with the children. And with the law enforcement, I just want to say real quick that with our cross-deputization agreement, it has been successful. It's been in effect since 1999. We have offered, the SLEC, the Special Law Enforcement Commission, the criminal justice force, so that those that are cross-deputized to enforce tribal law with this commission, they are able to fall under the umbrella of a federal prosecution if needed, if they are to be assaulted. That's one of the gap fillers that we've attempted to use at Fort Peck, because we cannot prosecute those crimes when law enforcement is involved with a non-Indian offender. Thank you, Senator.
Thank you. Assistant Secretary Little Elk, you've been in this new role now for a few months, and I'd like to get your perspective on common barriers the department sees with regard to the tribe's ability to implement special domestic violence criminal jurisdiction. As I understand it, in South Dakota, only the Sisseton Wahpeton Oyate and the Standing Rock Sioux tribe have taken the steps to implement this special jurisdiction. I know you touched on it a little bit earlier, but I'm just curious with regard to our local tribes. Why haven't other tribes in our home state implemented this expanded jurisdiction? What do you see as options that might make it more or more available to them?
Without taking the risk of speaking on behalf of our tribes in South Dakota, I can only speak from lived experience. But overall, from a national perspective, I think that one of the things that we consistently hear from tribes through various tribal consultations, including the Tribal Budget Advisory Committee and other forums in which we get to engage and hear directly from tribal leaders, is the resource challenges. This is one of the reasons why in our FY22 budget request, we've asked for an additional $58 million for justice services to make for a total of $507 million overall. The bulk of that, those resources of that request, really goes towards increased staffing and for law enforcement services on the ground, with an additional $5 million for tribal courts and tribal court O&M areas. And again, and anecdotally, I think that many tribes are looking to make sure that their law enforcement services, that their detention centers, and that their court systems are adequately staffed and fully functional before taking on additional and before asserting additional sovereignty and jurisdiction to take on the provisions as in VAWA.
Thank you, sir. Thank you, Mr. Chairman.
Senator Moran.
Chairman Schatz, thank you. Thank you and Ranking Member Murkowski for holding this oversight hearing. I supported VAWA in 2013, and I look forward to building on the tribal provisions that were contained in it. And I thank our witnesses for being here today. I'm the ranking member of the Commerce, Justice, Science Appropriations Subcommittee. The importance in this arena is the Department of Justice. And I'd like to direct my questions in regard to some of the appropriation issues. Senator Cortez Masto asked one of the issues I was interested in. The nearest FBI field office to a tribe in Kansas is not quite 90 minutes away. And I appreciate your question, and I appreciate what information we receive from the answers. But distance is always a problem for us in Kansas, and our tribes are not located, tribal lands are not located close to any cities, and so it is a significant challenge. This is a question I direct to any and all. Well, let me start with Ms. Randall. I'll ask you this question first. You mentioned the President's request for increasing funding at the Office of Violence Against Women's tribal-specific grant programs by $46 million. What gaps have you identified that additional funding would fill?
Thank you, Senator. One really targeted piece of funding would be for tribal special U.S. attorneys. That prosecutorial role is a gap that we would like to fill. We would provide more funding for tribal governments overall, and that's to implement everything from victim services to supporting tribal law enforcement. I think also very important is tribal jurisdiction, and we do have a specific program to help tribes implement, right? Tribes who haven't started yet to implement that jurisdiction to do so.
Ms. Randall, you mentioned also in your written testimony that the FY22 CJS bill includes new funding for tribal special assistant U.S. attorneys. You mentioned that's something still on the want list. But perhaps you can discuss with me a little more about the importance of this program.
Absolutely. Well, tribal special U.S. attorneys are cross-designated to be able to bring cases with a tribal expertise in the federal court, working, incredibly closely as members of the U.S. attorney team. And we've seen in many states that this allows the federal government through this program to bring significantly more prosecutions than we might be able to otherwise, and have the expertise of the tribal prosecutor who has been cross-designated.
And are those, I assume that tribal law and federal law and state law in regarding tribes is a significant specialty, not that every attorney would know. And I certainly would know that those who have experience either as tribal members or strong association with tribes would have a better understanding of cultural and other issues that would be of significant importance. Does a U.S. attorney in this circumstance, does the U.S. attorney select those individuals? They work for the U.S. attorney?
Well, you are exceeding my specialized area of expertise, Senator, so we'd love to take that back and make sure that we have all of the right details for you.
Okay, I'd be glad to hear more. I would point out that Senator Schatz and Senator Murkowski are members, as you would know, of the subcommittee that appropriates that we're talking about, and I look forward to working with them as we continue our efforts first to get this fiscal year completed, and as we will look forward to next year. Thank you for your answer.
Thank you.
Senator Moran, full disclosure, the Vice Chair and I were just praising you behind your back.
Surprised at your willingness to admit that.
Vice Chair Murkowski.
Thank you, Mr. Chairman, and to our colleague who is so adeptly spearheading CJS, thank you, and we will work on these initiatives. I wanted to ask just a couple one final question to Professor Reese, but first, Ms. Randall, I want to acknowledge the announcement that you've made saying that we're going to have this consultation in the annual consultation in Alaska. We'll look forward to welcoming you and being part of those. Thank you for that. Ms. Randall, we've all cited your report. Thank you for dealing with some of the concerns that so many had expressed following VAWA 2013. Despite the statistics, despite the report, there is still that doubt. You use the word distrust. I think there is still some concern. I certainly hear it in Alaska when we talk about the prospects for the pilot that we have outlined in our draft legislation. And I really appreciate that you've succinctly stated that, look, first what we have to do is clarify the law, because concerns are rooted in, you say, several fundamental misunderstandings of that law. I think that is correct. And the second is a simple reminder that tribal governments are American governments too, worthy of our trust and dignity. And your final statement is worth repeating. For those who would suggest that we shouldn't be moving forward with this special jurisdiction, Professor Reese states, our reasons for keeping them out of it are rooted in fear, distrust, and assumptions about their capacity to soundly administer the law that all ought to be long since in our past. I certainly agree with them. But I know we're still dealing with some of these ghosts of the past. And so I would ask, and it's directed to you, Professor Reese, but I'd also be willing to hear from our administration witnesses as well, as to what else is it that we have to do to gain the trust, to assure that there is a level of capacity that can be met, certainly with our proposal in the Alaska project. There is an effort where the Attorney General works with the tribes to determine those that will be able to provide systems that fully protect defendants' rights under federal law. There are protections that we feel that we have incorporated, but still we meet this resistance. Is it just fear of the unknown, even though these have been in place for 8 years? What more do we need to do? Because I've got some convincing with some colleagues who are not sure that this is going to be too experimental, that this justice will be too experimental. My response right now is, in many cases, there is no justice. That is the experiment that is happening, is no justice. And so I am willing to engage in some pilot projects that maybe push things out a little bit more beyond people's comfort zone, because right now, women are vulnerable. They're being destroyed because we don't have these protections. So we've got to do something different. But help me out with how we get beyond the distrust of this. And I'll turn to you, Professor, first.
No, absolutely. Thank you for the question and for the kind remarks about my testimony. So I would say that you could do several things. One of which is to take them to Indian country. Take them to Judge Stacy's courtroom and show off the amazing work that she is doing to provide justice for the people of her community. Because I think really seeing Indian country in action and justice in action, does so much more to generate that kind of trust than, all of the possible rights protections and laws that we could write up. When really, if what we're talking about is just a skepticism that's more deeply rooted, as you've said. So I would suggest that if possible, but I'd also, like you also said, right now there is no justice. So of course, certainly, trying something is necessary, but also to remind folks, not to hold tribal governments to a unfair and unrealistically high standard of perfection before we let them try out justice over fellow American citizens. I think if we expect them to be something that is, in effect, like perfect, infallible, always, delivering perfect rights, that's not fair. That's not the way court systems in the United States works. What happens in state courts as well is that, there are laws on the books that ensure that citizens are protected when they mess up. That's how laws and protections work, is to make sure that citizens are protected because courts aren't perfect. And so I think the same thing is in place in Indian country. We have these laws to protect and recognize that courts won't be perfect all the time. They're run by people, but they're necessary for justice.
And we have, in fact, in place the federal protections that are already afforded in law. It's not as if there is no due process that is at play here. Mr. Chairman, thank you so much for this hearing and for all of the witnesses that to your point, I think it has been extraordinary testimony that the committee has received, and I look forward to working with all of my colleagues as we work to advance this restoration of justice through VAWA. Thank you.
Thank you, Vice Chair Murkowski. I want to thank the staff. I want to thank the advocates. I want to thank the leaders in Indian country, our testifiers, the administration, everybody who's moving forward with this legislation. We are on our way. If there are no more questions for our witnesses, members may also submit follow-up written questions for the record. The hearing record will be open for 2 weeks. I want to thank all of the witnesses for their time and their testimony. This hearing is adjourned.